Good morning. Welcome to this meeting of the Standards Panel on Friday, the 22nd of July, 2022. Can I ask for nominations for chairman, please?
If I could nominate Councillor Knowles as chairman, please.
Can I just confirm that Councillor Nicholson has seconded?
Thank you very much, colleagues. Good morning, everybody, and welcome to this meeting of the Standards Panel. I've been asked to say that, as it's rather humid, if gentlemen wish to remove their jackets, they may. The air conditioning is keeping it fairly cool at the moment, though, but should it have to go off or anything, please feel free to do so. Declarations of interest. Are there any declarations of interest, please? Councillor Rabini.
Thanks, Chair. Several to make, I think. Obviously, as a town councillor, I have worked closely with Councillor Ellis and any other town councillors or representatives here. I've also worked with Councillor Ellis on the vision, with the neighbourhood plan and various other projects. So I'd like to declare that I'm still objective. However, there is an association through the town council. Thank you.
Thank you. Councillor Nicholson.
Thank you. Yes, I'd like to say that Councillor Ellis is a colleague of mine on Hazelmere Town Council.
Thank you. Item number 3 now is the publication of the non-exempt agenda papers to the press and the public in line with paragraph 7.2 of the Waverley's arrangements for dealing with standards allegations against councillors and co-opted members under the Localism Act 2011 to publish non-exempt meeting papers and make them available to the press and public. Panel members and other individuals specifically invited to attend the hearing have received the agenda papers in advance on a confidential basis. There are no exempt papers for this hearing. The recommendation, colleagues, is that the meeting papers be published and made available to the press and the public. Is that agreed?
Agreed.
Thank you. Item number 4 is the chairman's opening remarks on the procedure and how we will proceed throughout this hearing. Much of this is set out in the agenda paper, but I will start by introducing ourselves. If not already known, I'm Councillor Robert Knowles. I'm a member of the Council for Hazelmere East and Grays Wood, and I'm joined by Councillor Rabini, who is a member for Hazelmere, Shottermill and Critchmere, and Councillor Nicholson, who is a member for the same ward. I will ask the officers who are here to introduce themselves so that everybody knows who everybody is. So if we can start with Mr. Taylor, please.
Thank you, Chairman. Robin Taylor, Head of Policy and Governance and Monitoring Officer at Waverley Borough Council.
I am Solicitor, Guildford Borough Council and Legal Advisor. Good morning.
I'm Stephen Ricks. I'm the Interim Borough Solicitor at Waverley Borough Council, and I'm also the Lead Legal Specialist and Monitoring Officer from Guildford Borough Council.
I'm Daniel Bainbridge. I used to be Borough Solicitor here. I was involved in the investigation with Mr. Taylor. I'm here as a witness with Mr. Kenyon. I'm now Head of Law and Governance and Monitoring Officer at Arran District Council.
Morning, I'm Melvin Kenyon and I am the Independent Investigating Officer.
Vivian Cameron, independent person.
Thank you. And I should have said, and Councillor Stephen Reynolds is the representative of the parish councils, and he's a councillor at Elstead. Could I ask you to introduce yourselves, please?
So I'm Brenda Roper. I'm here with Kirsten as her advisor. And perhaps if we're looking at interests, I'm also a safeguarding investigator for local authorities.
I'm Kirsten Ellis, Hazelmere Town Council, an independent.
Thank you very much. You just check that everybody has, that you have got the full set of papers. Thank you. Well, the procedure is very much set out on page 14 of the agenda. The points that appear to be in contention and how we will conduct the hearing, which we will follow as far as possible. And everybody will get their opportunity to make statements, and then there'll be questions as necessary from the panel. So to start the hearing, I will ask for a statement from the investigating officer, and his report is at Annex 3.
Okay, thank you, Chair. Can everybody hear me? I was commissioned by the monitoring officer of the Borough Council to act as the investigating officer for 2 standards complaints made against Councillor Ellis of Hazelmere Town Council. I'm here today to present my investigation report, which is part of your pack, and to answer questions about it, and I'll be summarising it briefly for you in a few moments. But first, I do want to make a quick point which the panel might wish to bear in mind as they deliberate, because on the occasions when the work of an investigator like me is examined in a standards hearing, it's not uncommon for subject members to do 2 things. First, they suggest that an investigator has been biased or unfair in carrying out their investigation. This is something, by the way, that disappointed complainants are also apt to do if investigators find there's been no breach of the code of conduct. This is not unusual, and I'm afraid is an occupational hazard for an investigator. And so it is for me here. On page 143, Councillor Ellis accuses me of using artful language, of suppositions and musings, and of non-neutral and subjective comments. A final comment in the statement that she submitted just before we all sat down today says his many interleave references to both codes cast doubt on his objectivity. She doesn't say, though, why I might be biased. In fact, I do everything I can to be objective. My reports follow a strict process of findings, conclusions, and recommendations with a golden thread between them. My conclusions are based on the facts and the evidence available to me and on the balance of probability. My reports are always peer-reviewed. I'm not biased, and I'm certainly not in anyone's pocket. The second thing that subject members typically do is to try to get the hearing panel to focus on the process that has been followed and other extraneous matters, rather than on the core allegations that it needs to consider. That's certainly true here in Councillor Ellis's response, which begins at page 111 of your bundle. She spends much of its 37 pages talking about past events and about alleged abuse of process without really focusing on the core issues. Most of the allegations about process were dismissed last year by Mr. Corndall, whose independent report you can find at page 286 of your bundle. I'm wondering whether by raising the same allegations of unfairness again, Councillor Ellis thinks that Mr. Corndall's report, like my own report, was biased and unfair. So, on to my report. I'd like to direct the panel to what is relevant out of this very large bundle of largely extraneous material. And that is whether Councillor Ellis breached the Hazelmere Town Council Code of Conduct, a copy of which is to be found at page 19 of your bundle. That and only that is what the panel is here to consider when it gives its conclusions. My report can be found at Annex 3 of your bundle, as the chair has said, beginning on page 33 and ending on page 109. I'll assume that you've all read the report, but I'm of course happy and expect to take any questions you might have. Section 8 of the report, the evaluation of evidence and conclusions, is perhaps the most important part of it, and it runs from page 91 to page 100 of your bundle. To reach my conclusions, I had to answer 4 questions, and we'll look at each of them briefly now. Question 1 is, was the subject member, Councillor Ellis, acting in official capacity when she attended the Hazelmere Town Council meeting on the evening of the 28th of November 2019 and at all other relevant times? I hope we can all agree on this. Councillor Ellis participated in the whole of the Town Council meeting as a Town Councillor and was also in capacity at other relevant times. Therefore, beyond doubt, I think that she was in capacity, though I am, of course, happy to take any questions that the panel might have on that. Question 2 is, was Hazelmere South Residents Association, which I'll refer to for the most part as HSRA, a, quote, body one of whose principal purposes includes the influence of public opinion or policy? This was for me the critical question, but my evidence and conclusions on the matter aren't really addressed at all in Councillor Ellis's subject member's statement in your bundle. Please note the exact wording here because it's really important. A body, one of whose principal purposes includes the influence of public opinion or policy. Those words tie directly back to the words in the Declaration of Pecuniary Interests, which you can see at page 169, and to clause 5.5 of the Code of Conduct on page 22. Let's begin with HSRA's constitution. It says that HSRA's objectives were to promote high standards of development, conservation, planning, traffic management and safety in the area, to enhance and protect the community interests of those resident in the area, to enhance and protect the community interests of those community educational and sport and leisure organisations and associations in the area, and to represent the views of its members on local, neighbourhood and environment matters generally. Now, setting Red Court aside for one moment in favour of a more general point, that part of HSRA's constitution leads me to ask how HSRA was actually going to achieve those objectives unless one of its principal purposes was to influence public opinion or policy. But let's leave that to one side for now. To establish the true nature of HSRA, I relied very heavily not on what people said to me, but on hard evidence from HSRA itself. And you can see that in my report. That included HSRA's own website, which I deal with at section 7.3.1. Other documents like its own minutes and announcements, section 7.3.2, and the contents of its own Facebook page, section 7.9, and also its Twitter account. To repeat, this is hard documentary evidence deriving from HSRA itself and not from what anyone said to me. And there's a lot of it, and it's not all referred to here. The evidence about the nature of HSRA was completely conclusive. To help illustrate that, I'm going to pick one apparently small, but I think very telling piece of evidence from the many I considered that you can see at page 56 of the bundle. There I talk about the application form that prospective members have to complete to join HSRA. The digital file name given to the HSRA application form by whoever created it was Save Scotland Lane form. To repeat, it's Save Scotland Lane form. That's very revealing in my opinion. Then the form itself contained the text, please tick this box to indicate that you're happy for us to hold the above data only for the purposes of campaigning against the inclusion of Redcourt in the development plan and any subsequent planning application. So what it was saying was that the personal data, this was about GDPR, I assume. So what it was saying was that the personal data of members of HSRA was to be used only for campaigning against development at Redcourt and nothing else. That seems to me to be a very, very narrow definition. And I remind you that this is or was HSRA's own form. Elsewhere in the evidence in my report, you'll see that the word fighting is used. This is the language of battle, of campaigning, and it really couldn't be very much clearer. As you'll see in my report, I was extremely, if not 100%, 99% certain that HSRA wasn't set up to draw the council's attention to dog mess or speeding cars, to organise Easter egg hunts or distribute food parcels. It was set up actively to oppose the Redcourt development and, by the way, to raise money to do that. To quote the Declaration of Pecuniary and Other Interests, that was one of its principal purposes. That much is very obvious. In fact, you'll see from my report that it was HSRA's primary, and at that time, even perhaps sole purpose when it was set up. So given that one of HSRA's principal purposes was to influence public opinion or policy, and especially in relation to Redcourt, it follows irrefutably that there was a requirement for Councillor Ellis to register her membership of HSRA in her Declaration of Pecuniary and Other Interests. Moving on, as time passed, one obvious way of opposing the development at Redcourt was to make sure that Redcourt fell outside the settlement boundary, something that is discussed in some detail in my report at page 56 and 57 of your bundle. On an HSRA website page entitled Details on Neighbourhood Plan, it was actually N-Plan, but Neighbourhood Plan, which summarised the outcome of the 28th of November meeting, there was a sentence that read, "With a formal boundary now defined, planning permission for large developments will be harder to obtain." Later it said that the formal and defined and recognised settlement boundary will make planning of development outside this boundary very difficult. Redcourt is naturally part of this area, protected area, it said. There was no doubt then about the importance of the settlement boundary to HSRA. So as a result of my detailed desk-based research from HSRA sources alone, and not from discussions with Messrs Cox, Benson, Leet, council officers or anyone else, I was 100% certain that from its earliest knockings in June 2018, and that's almost 18 months before the town council meeting, HSRA had been set up to fight the development at Redcourt. Furthermore, I was left in absolutely no doubt at all about the, and I quote, overriding importance of the proposed Redcourt development and the settlement boundary to HSRA and its members. I didn't even need to weigh up the balance of probability here. I was certain that HSRA was a body, one of whose principal purposes was to influence public opinion or policy, perhaps in a number of minor ways, but in particular in respect of Redcourt. In doing that, it also had a clear and demonstrable interest in the settlement boundary. And I'm happy to take any questions on this. So, having established the nature of HSRA, I turn to the third question. Was Councillor Ellis a member of HSRA? Did she declare that on her Declaration of Pecuniary and Other Interests? I look at this question at section 8.3.1.2 on page 96 of your bundle. Councillor Ellis has herself confirmed that she was a member of HSRA, and indeed that she was a committee member from an early stage. Whilst we could discuss whether she was a founder member, and I have evidence that suggests she was, I think we can agree that she was a prominent member of HSRA. And given the nature of HSRA as a body, one of whose principal purposes was to influence public opinion or policy, any member of HSRA who was also a town councillor had a duty to include that on their declaration of pecuniary and other interests. But for whatever reason, Councillor Ellis did not do that. She knew that it was an organisation that she had to put on the form, but instead she chose words which read, and you can see these on page 169. I've been asked to advise and observe Hazelmere South Residents Association and represent members, which she amended more than a year later to confirm that she was indeed a member of HSRA. We believe that an ordinary member of the public would have been less clear about what that meant than they would have been if she'd simply said on the declaration that she was a member of HSRA, as she did in September 2020. In May 2019, she was a member of HSRA, as she was in November 2019. The form requires her to declare that membership, but she did not, though she clearly saw the need to put something in that box when she filled the form in. We do not believe that her relationship with HSRA was properly declared as she said it was. Those are her words, properly declared. All she needed to do was say she was a member, and she should have said so, but she didn't. So we've established that Councillor Ellis was a prominent member of HSRA, but whilst recognising that she needed to refer to HSRA on the form, she chose another form of words to describe her involvement with HSRA, even though she was a member, and the declaration of pecuniary and other interests required her to declare that membership. Again, I'd be pleased to answer any questions you might have on this via the chair. And I'll now move on to the last question. Should Councillor Ellis have declared an interest in the item that discussed the neighbourhood plan at the Town Council meeting on the 28th of November 2019? And if so, did she make such a declaration, and having done so, did she withdraw from the chamber? The answer to this final question centres on the link between the neighbourhood plan being discussed that evening and the settlement boundary, which was of such interest to HSRA. That link is clear. The version of the neighbourhood plan being considered that evening contained a redrawn settlement boundary that set Red Court outside the settlement boundary. In the previous version, in March 2019, and before the so-called New Eyes review, of which Councillor Ellis had been part, Red Court had been inside the settlement boundary. This was a crucial change to the neighbourhood plan as far as possible development of the Red Court site was concerned, and it would be disingenuous to suggest otherwise. Councillor Ellis said, and you can see it on page 87 at point 40, the complainants seek to show that a causal nexus exists between HSRA and the settlement boundary. Such a causal nexus does not exist, not even tenuously. Now, without discussing the semantics of what a causal nexus might be, we've already touched on this question and seen that those who were writing material for the HSRA website soon after the 28th of November meeting saw a clear connection, not a tenuous one, a clear connection between the settlement boundary and the Red Court development. They knew that the redrawing of the settlement boundary was highly significant for potential development, and so too did the complainants. So too did Councillor Ellis. Councillor Ellis had herself taken part in the Fresh Eyes review of the neighbourhood plan after her election in May 2019. She took an active part, and she told me she's a professional writer, in the detailed drafting of the document, which you can see on page 76. And she was present at the 30th of October Neighbourhood Plan Working Party, which discussed the settlement boundary at some length. So, as we have said on page 102 and 103, it seems extremely unlikely to us that Councillor Ellis can have been unaware at the time, and by that I meant at the meeting, of the potential significance of the location of the new settlement boundary proposed in the revised neighbourhood plan to possible development of the Red Court / Scotland Lane site. In fact, with the benefit of the passage of time, I would say that it's inconceivable that she didn't know of its significance. On that basis, Councillor Ellis should have declared an interest at the 28th of November meeting, and she did not. She went on to take a full part in the apparently prolonged debate and the subsequent vote on the neighbourhood plan. She did that even though the Hazelmere Town Clerk, Lisa O'Sullivan, had written to her before the meeting, inviting her to think about whether she should declare an interest, and that perhaps should have alerted her. Furthermore, I believe that an ordinary member of the public with knowledge of relevant facts would have thought that her membership of HSRA had sufficient weight so as to undermine her ability to make an open-minded and objective decision. Now, a key point here is that the test at law for apparent bias is whether the circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility or a real danger that the decision maker was biased. In general, and this is important to understand, the rule against bias looks to the appearance of the risk of bias rather than bias in fact, in order to ensure that justice should not only be done, but should manifestly and undoubtedly be seen to be done. To quote a leading judgment in the field, and that is Kelton versus Wiltshire Council from 2015, quote, all councillors elected to serve on local councils have to be scrupulous in their duties, search their consciences, and consider carefully the propriety of attending meetings and taking part in decisions which may give rise to an appearance of bias, even though their actions are above reproach. So, to summarise, my report to the monitoring officer contained 3 conclusions. They were, number 1, that by failing adequately to register her membership of HSRA, Councillor Ellis breached paragraph 5.5 of the Code of Conduct, which requires registration of non-pecuniary interests as defined in that paragraph, as HSRA is a body, one of whose principal purposes is to influence public opinion or policy. 2, by failing to disclose her membership of HSRA at the 28th of November meeting, she breached paragraph 5.5, which requires disclosure of non-pecuniary interests as defined in that paragraph. And 3, by failing to declare that interest and failing to exclude herself from consideration of item 109/19 by withdrawing from the chamber, she breached paragraphs 5.1, 6.4 and 6.5 of the Code of Conduct, which you can see on page 21 and 23 of your bundles. After I submitted my final report to the monitoring officer, at that point it became his report. It was for him to issue the report and to determine what to do next in accordance with the council's arrangements for dealing with standards complaints. And that's why we're here today. Thank you for listening. I'll be pleased through the chair to answer any questions that the panel might have on any of this. Thank you.
Thank you very much, Mr. Kenyon. Do you wish to call any witness? I'm assuming not.
Well, I will call Mr. Bainbridge simply to get him to, or to ask him to give his views on the conversation, and I use that in the broadest sense that he had with Councillor Ellis about the declaration of interests.
Thank you, Mr. Bainbridge.
So I think you'll see in Mr. Kenyon's report that I spoke to Councillor Ellis. Councillor Ellis instigated the conversation, called me in November 19, and that was followed by an email about a week later. I think Councillor Ellis asked for just a follow up on that conversation. I replied to that. So effectively, my note of that conversation is in that response because the advice didn't change. The advice given was fairly standard, and it reflected the advice that was given during the training session at Hazelmere Town Council back in earlier in 2019, when similar questions came up about what should councillors do in situations where they might be looking at the sort of decision that obviously Hazelmere Town Council was looking at that time regarding the plan and so on. And that advice was to give councillors, and then specifically Councillor Ellis, when I spoke with her, a framework within which to make that decision. I think councillors always look for an answer from the monitoring officer or deputy monitoring officer of, can I sit in the chamber? And I don't think it's ever my view. Others may have a different view, other monitoring officers might have a different view, but my view is that it's not my job to act as a policeman or a bouncer and say you mustn't sit in the chamber. You can give very, very strong advice and say, look, I really don't think you should, but it's ultimately always the councillor's decision. And so what I was trying to do in that conversation and in the training session was provide the framework of, that a councillor would follow to then think things through and reach their own conclusion, because it does have to be their own conclusion. The responsibility sits with them. So that was really, that was the only time that I spoke with Councillor Ellis, and then obviously corresponded with her prior there, obviously, to the complaint and the investigation. I think there were some emails later on in 2020 during the informal stage of the investigation. Just checking whether there's anything else that I wanted to pick up. I know the point's been made by Councillor Ellis that in her statement that I'd admitted that my advice was unclear or insufficient. That wasn't the case. What I said in an email to her was that I was apologising if she found it unhelpful. Now, that's quite a common phrase. I'm sorry if you found the advice unhelpful, but the advice is what it is ultimately what I was saying there. It wasn't me saying my advice was wrong, and I apologise for that. My advice was right in my view, and I've reviewed that email obviously a number of times during the informal investigation, during the formal investigation by Mr. Kenyon, and so on, and again today. So I did just want to clarify that point that was raised in the statement. That's all I have to say, unless I can assist you further.
Thank you very much. Now, colleagues, questions. If I just, from what you've just said, Mr. Bainbridge, perhaps you could help us with this. You referred to a training session at Hazelmere Town Council. I don't know if you were present at that, or if you can tell us kind of what form that took.
I was present at that. So that was following the 2019 local elections and part of the induction programme for councillors across the borough. The monitoring officer and I and the other deputy monitoring officer at the time, Fiona Cameron, went around the towns and parishes and supported them, the clerks and their councillors in terms of training in standards. So I was there on that occasion. It was chaired by Councillor Round, I think he was chair of Hsra Town Council or mayor at the time. The clerk was there, and a number of Hsra Town councillors were there. And the format that it took was, I think it was a PowerPoint presentation for them, and then questions afterwards, various questions. One of which, of course, was, as I say, was around planning applications, proximity to sites, those sorts of questions, the sorts of things that come up in induction training every 4 years. So that was the format.
Thank you. I don't know if you can help us anymore. Were any particular sites raised or any guidance given with regard to that, such sites or memberships of associations?
Questions were general. I think I seem to remember that the questions were general. Obviously, there are specifics behind those questions, but I think when you're giving advice in those scenarios, monitoring officers, deputy monitoring officers always say, well, it's clear that you've got specifics in mind, but you have to approach things on case-by-case basis, and we'd encourage councillors to approach us individually another time, around specific cases, because it's otherwise those sorts of sessions just run away in terms of the time and so on. Was Red Court specifically mentioned? I can't recall, but I do remember giving specific advice around, around proximity to sites and so on, and how you would reach a decision as to whether you have an interest or not. Can I remember Red Court being mentioned? No. Declarations of interest? No, that was not mentioned. That's not a question that was asked.
Thank you. That's most helpful. Colleagues, any questions? Councillor Rabini.
Thank you, Chair. 2 or 3 minor things. First of all, Mr. Kenyon, how did you establish that Councillor Ellis was a member of the HSRA? I know we've been talking about it here and she's mentioned it a few times. Obviously, the relevant date is when she first became a councillor, and again when the planning was starting to be discussed on the 28th of 11th, which of course we are open then to declare a non-pecuniary. Did you establish through a membership contract or something that she was a member of this, or was it purely on her own admission?
So you put your microphone on because, sorry.
I'm not used to this. Councillor Ellis said she was a member.
So you had no administration to prove that she was a member at the time?
I had no administration to prove that she was a member at the time, but if she tells me she was a member, as far as I'm concerned, she was a member.
Okay, thank you for that. The other point is this is a very small one. On page 113, you'll see that there's under item 1.10, there's a reference to myself about the misrepresentation of what they were doing at Redwood. Can I just make the point, please? I was not a councillor in June 2018. I didn't get elected 2019, so that in itself is in the wrong place, I assume. And of course, when Mr. Bainbridge came down to do the lectures, I was in fact mayor at the time in 2019, although I don't think I participated in that one because I'd already had the training at Waverley. My only other question is, we are looking at this because the Hsra Town Council rules were not clear, for example, on proximity to properties to Redwood, and we do not discuss that here. Can I please ask and make sure that you were happy that the Hsra Town Council rules at that time were clear about a pecuniary or a non-pecuniary in the instance we're looking at now? Okay,
the first point I would like to make in response to your first point is that page 113 is a timeline that was prepared by Councillor Ellis. As there were certain aspects of the code that were not clear, but the code was clear when it came to the salient point of declaring membership of an organisation. I can't remember the exact phrase, but whose purposes were to influence policy and so on. It was clear as far as that was concerned, yes.
Mr. Kenyon, can I just draw your attention back to on page 103, the second paragraph, which starts a few weeks later, the Scotland's Close Residents Association in minutes. Kirsty, and then there's a redacted name, thanked in their absence for the hard work in the matter and making it harder for Red Court to get planning permission. Is that a straight lift from minutes? That is a straight lift out. Thank you. Just wanted to be clear that was the case. Would you like to? Thank you.
Yes, thank you, Mr. Chairman. I think there are some things that would be helpful if Mr. Kenyon could clarify for the panel. But before I say that, can I just say the settlement boundary that Mr. Kenyon talks about being redrawn wasn't redrawn. It was returned to its original boundary, which is not quite the same as saying that it was redrawn. So one of the things that we're interested in is the difference between Mr. Kenyon's draft report and his final report. And I was wondering what led him to change his mind. And if he's able to clarify that for us, please.
Can I check that before I answer that question, that it is appropriate to refer to a draft report rather than a final report? I'm not sure I'm directing that question out, whether it be our legal friends over there or...
I will take advice from the senior legal advisors. Thank you. Please.
We advise that the question is answered.
Yes, there's some significant differences in your findings between the final report, between the draft report, which was circulated, and the final report. Oh, and I was wondering, we were wondering, what caused that to change?
Okay, I think you will find if you look at the draft report that the changes are not marked as far as the findings are concerned. I think you will find that it's largely to do with the conclusions as they were written. The main reason for making the change was that the original, obviously I took on board any comments that had been made by Councillor Ellis and indeed another subject member who'd made comments, and also by the complainants, in order that the conclusions would be clearer. The original conclusion from memory referred to something called the new model code, which is a document that was produced by the LGA, can't remember exactly when it was, but I think it was in 2020 or 2021, which clarified the difference between pecuniary interests, non-pecuniary interests, and I think other interests. And that was the main reason for making the change. I think, and please correct me if I'm wrong, Councillor Ellis, that Councillor Ellis didn't like references to the new model code. Certainly there were those who didn't like references to the new model code. So I went back to the references to the existing code. The references to the new model code were included to be very clear about the difference between pecuniary interests, non-pecuniary interests, and other interests.
Thank you. Any further
Mr. Chairman, it seems unlikely that Councillor Ellis would have requested 2 additional breaches to be added to the final report. But moving on. When Mr. Kenyon interviewed Mr. Cox, who's one of the complainants, he allowed the director, a director of Redwood, to be with Mr. Cox, describing him as an advisor, which is, I hesitate to say, but it's something of a misnomer. And I was wondering if Mr. Kenyon would be kind enough to tell us why he allowed Mr. Cox to have another director of his company with him, somebody who clearly had a pecuniary interest.
Two answers to that. I can interview whomsoever I like. And secondly, Mr. Leet was, I don't know if he's, well, he was a director at some point of Redwood Southeast, Redwood Southwest. Redwood Southwest were the original complainants via Clark Wilmot, and therefore it seemed perfectly reasonable to me to interview him or to allow him to be present with Mr. Cox.
Thank you. Thank you. Is that for now? Is that it? Thank you. Thank you.
Can we explore the HSRA a little more? Work through the chair if you're happy for that to happen. Were you aware of the work that the Hazelmere South Residents Association had done around the development of the Heights in Hill Road?
No.
And what about the work that Hazelmere South Residents Association has done regarding the highways and Scotland Lane? There has already been another serious accident at that junction this morning. Highways came out and were hosted by Hazelmere South Residents Association to look at that junction, their safety officer. So it seems, whatever it says on the website, Hazelmere South Residents Association isn't just about Red Court.
I don't know what Hazelmere South Residents Association is about now, today, but I know that in its original genesis, it was about resisting development at Red Court. One of its principal purposes, I will have to go back to this to quote, was to influence policy in respect of Red Court. That's all I need to show, one of its principal purposes, and that's beyond doubt. Documentary evidence beyond doubt.
Thank you very much.
Can I just also look at the complainants? Because Mr. Benson, as we know, is a serial complainant, and I don't think there's any question about that. He's raised complaints about other councillors over time. Nowhere in your report do you look at the fact that he's been trolling Councillor Ellis, that there have been breaches of confidentiality, that he has taken photographs of Councillor Ellis's ex-husband's home where her child lives. Did it ever occur to you that these complaints might be vexatious or malicious?
Whether the complaints are vexatious or malicious isn't my concern. That's dealt with by the monitoring officer and the independent person before they pass the complaint to me to investigate. It isn't my job to do that. I take the complaint that's passed to me and I have no knowledge and had no knowledge of whether Mr. Benson was a serial complainant.
I think we need to be careful what we say to anything that isn't that you haven't got evidence of. I think we need to be very, very careful, and those are not the views of the council. Thank you very much. We'll now move to a statement by Councillor Ellis, and you will also be given the opportunity to call any witnesses, and I would ask that we do major on the three issues set out on page 14 and don't go too far away from that or make any allegations which we can't substantiate. Councillor Ellis.
Thank you. Before I start, I just want to answer to Mr. Kenyon's query. No, I did not think that Mr. Stuart Corndall was the external advisor in this process. No, I do not think that Mr. Corndall's report was biased. He made it very clear that his terms of reference were what his terms of reference were. I didn't find any bias at all. And also I am not responsible for HSRA's website or Facebook communications. I'm a member, very simple. I want to establish that from the moment of being elected as a new councillor, I have always set out to uphold the Hazelmere Town Council rules of conduct and represent the people who elected me. I ask you to accept that I acted in good faith in this matter. I do not accept any findings of dishonesty or evasiveness that Mr. Kenyon has gone to lengths to construct in his report, 76-page report. His lengthy final report, if closely analysed, is based entirely on his interviews with, aside from the town clerk, people who have a pecuniary interest. One might have expected, as a supposedly neutral investigator, that he might also have canvassed at random the objective views of some reasonable-looking people going about their business in South Hazelmere, instead of simply substituting his own. At the time of my complained of vote, I was a new councillor, elected on a pledge to do my best to look after our town's environment, nature and green spaces. My campaign statement refers to my membership of Hazelmere South Residents Association, and I believe that was published in the Herald. When elected, I declared my ownership of property on Scotland Lane as part of my declarations of interests and accurately described my relationship with HSRA, and also stated that I had stepped down as committee member. It is implicit in my wording that I was a member. That was clear to me. As I stated, that being an advisor and observer, it was clear that that was implicit to me. And when it was later pointed out to me that perhaps simply to say member would be preferable when this was pointed out to me by the town clerk, I immediately did it. I felt it was clear, as I state. It is totally misleading and inaccurate to say that I did not fulfill my duty to make my declarations properly as required under the Hazelmere Town Council Rules of Conduct, as Mr. Kenyon does in his final report, stating that in his opinion, I breached 5(1) and 5(5), suggesting that I did not declare correctly. Indeed, in his own draft report circulated to all parties, he did not find I was in breach of these clauses. Who or what made him change his mind? His findings are not supported by the evidence found in my declaration of pecuniary and other interests in Appendix 3. In all good faith and conscience, I interpreted the rules relating to non-pecuniary interests ahead of this vote. I found the rules in place at the time of my vote 2 years and 8 months ago unclear, which is why I sought out exact guidance from Mr. Bainbridge on how to apply them. Mr. Kenyon's report has explicitly acknowledged that the rules at the time, especially those relating to non-pecuniary interests, were woefully vague and lacked granular guidance. They have since been revised and are now more precise. Before the vote, I was advised by the town clerk that I should speak to Waverley's Democratic Services in case I might have a non-pecuniary interest to declare. Seeking guidance, I called twice and had an exchange of emails with Mr. Bainbridge. Naturally, being a newcomer to council, I needed and wanted clarification about how the rules should be interpreted and applied. I laid out for Mr. Bainbridge the location of my property and the status of my membership of HSRA. He advised he did not think I could be considered to have any pecuniary interest. He did not say that because I lived adjacent to the Red Court site, that this would be considered a non-pecuniary interest either. Both of these have been since confirmed. There is no housing schedule to be built adjacent to my property or that I would overlook. Indeed, the issue of my property was acknowledged not to be of concern as a focus of interest on non-pecuniary for Mr. Kenyon. If it has been claimed that my only interest was voting against the development or following the dictates of a neighbourhood group, I would not have called and emailed twice in my efforts to understand, or said to Mr. Bainbridge, I need to know what the right thing to do is. Please just tell me what to do and I'll do it, which is what I did actually say. Mr. Bainbridge said he could not advise me exactly what to do on non-pecuniary other than what Mr. Bainbridge has set out, other than I should examine my conscience, my own conscience, ask myself what a reasonable person with a reasonable grasp of the facts in my community would think under the circumstances. With that instruction, I made my own judgment call. It has to be remembered here that the vote was not about Red Court specifically. It was not a planning committee application, but a full council vote about the neighbourhood plan and boundary which affected all of Hazelmere. It was therefore a matter in which each and every single one of the councillors had an interest. Indeed, all councillors who voted lived within 500 metres of either the boundary, a green space, or a potential site development. The vote was to keep the original Hazelmere boundary consistent with the public consultation that had been carried out for 6 years for the neighbourhood plan, because it would be considered unethical by any reasonable person that it should not, after the fact, as had been proposed, include areas of outstanding natural beauty for development, namely Red Court and Long Dean. My vote, to be clear, was to keep the original boundary, not change it. In my effort to do the right thing, I also consulted the local government, the LGA Association guidance, local government association guidance. And to quote from that, the Localism Act makes it clear that it is proper for councillors to play an active part in local discussions and they should not be liable to legal challenges as a result. This will help them better represent their constituents and enrich local democratic debate. People can elect their councillor in the knowledge that they will be able to act on the issues they care about and have campaigned on. I asked a few members of my community, reasonable people on the street, what they thought. I remember very well what I was told. One person said, I voted for you as an independent based on your platform because I thought you would represent my views, because the Conservative councillors I voted for last time repeatedly haven't listened and voted against my wishes. I was told bluntly, if you don't represent us at this important vote, then what's been the point of voting for you? I listened. It should also be borne in mind that when I voted, of all the other town councillors who also voted, not a single one declared an interest of any kind. Yet a retrospective analysis would have shown that 2 of them could be considered to have had a live pecuniary interest in relation to the property developer of Long Dean. No one complained about that. No one was motivated to. Yet clearly these councillors, both former mayors, obviously made exactly the same judgment I did and determined that for a Hazelmere-wide vote, they had no need to make their pecuniary declaration. Turning now to the source of the complaints against me. The complaints were made by people with a pecuniary interest or who were in a close association with people with a pecuniary interest in the Redwood development project. The complaint was motivated by the developer's wish to stifle and discredit a councillor who was merely representing the views of her constituents at a vote. Local opposition to Redwood's development has been huge, substantiated by the 9-to-1 vote supporting the neighbourhood plan referendum, which excluded it. This local opposition was reflected in both the majority votes by Hazelmere Town Council and Waverley Borough councillors who rejected Redwood's project to profit from building over a beautiful biodiverse greenfield habitat, not only at the planning committee, but also as part of the local plan part 2. Any doubt that I was representing the majority view in my vote is dispelled by the fact that a record number of 543 residents from all over Hazelmere sent written objections. By contrast, 4 letters of support received for Redwood's project happened to directly correspond to the complainants, including Mr. Benson and family. When I voted in November 2019 with the majority, It was to support local democracy for the common good of the Hazelmere community, which in this particular case was not to allow two important areas of outstanding natural beauty to be included. And I will add that Red Court is a combination of outstanding natural beauty and an area of, an AGLV. Redwood purchased Red Court, an extensive area of meadows, hedgerows, mature trees, adjacent to the South Downs National Park, full knowing that it was a designated landscape and a habitat for endangered wildlife species, but seeking to make a huge amount of money out of it anyway. Several nationally well-regarded experts had documented the AONB as not only of local but regional importance to ecology and biodiversity. Turning back to the complaints made about me, I want to place on record my own complaints about the nature and content of these complaints and the way in which they were pursued by the complainants and upheld by the monitoring officer in this process. I took a selection of Mr. Benson's complaints as submitted to the monitoring officer to the Surrey Police. I was alarmed by ones where he alleged that I was a danger to his person and property. I was alarmed by the fact that photographs had been submitted of my ex-husband's home driveway and car and my own. It was the Surrey Police view that they presented a clear case of defamation and suggested that the council take action against Mr. Benson on my behalf. Acting in concert, the complainants made serious allegations accusing me of criminal wrongdoing. They demanded the monitoring officer force my resignation, impose whatever maximum penalties were possible, and have me banned from participating in politics for 5 years. One said that councillors like me, female independent councillors, should be sent, I quote, to the graveyard of politicians. Their unreasonable, unhinged complaints, the latter quite misogynistic, in themselves should have given Mr. Taylor pause. Instead, he gave the complainants anonymity for 8 months into this process due to the, quote, high degree of emotion expressed by the complainants. Parallel with this investigation has been a 2-year campaign of online trolling involving one or more of the complainants, making smearing, defamatory comments in social media and in the local newspaper about myself and other Hazelmere and Waverley councillors who opposed Redwood's project. I'm happy to supply copies from Facebook, Twitter, and the Hazelmere Herald to anyone who wants to follow up on this and on the Waverley web, I should add. As a result, no doubt, of the social media whipped up, I had criminal damage to my property. Surrey Police again opened, Surrey Police opened 2 further pins for criminal damage and harassment. Nowhere in the documentation provided, including Mr. Kenyon's final report, is there any indication of the rationale for not concluding that the complaints about me were orchestrated, vexatious, or possibly malicious. Nor does Mr. Kenyon show he considered whether Mr. Benson's complaints were defamatory, as Surrey Police said they considered them to be. It has been said by the monitoring officer and applied by the independent person that I have rejected informal resolution of this matter. On the contrary, it is the complainants who have at each stage objected to informal resolution and have pursued the monitoring officer vociferously with their complaints for more than 2 years. The highly redacted email trail reveals they placed him under unusual and considerable pressure to acknowledge, uphold, and further their complaints. On this basis, he determined this must go forward to lengthy Inquisition-style treatment sustained for more than 2 years, involving a hefty cost to the Waverley taxpayer. Surrey Association of Local Councils informed me that it is very unusual for the matter of a non-pecuniary breach complaint not to be swiftly and informally resolved at minimal cost to the taxpayer. That has not been the case here. It ought to have been very simple. It has been dragged on for more than 2 years, 2 years and 8 months by the complainants and the monitoring officer. SALC acknowledged the stress and toll such prolonged investigation imposes. 5 months into this investigation, the monitoring officer told me that it was possible that I had a non-pecuniary interest to declare, but it had not been decided on the balance of probabilities as to whether I had or not. For 8 months, the monitoring officer withheld from me the identity of 2 of the complainants and much of the substance of their allegations. Usually, this kind of anonymity is only granted in cases of gross sexual misconduct or harassment. Mr. Taylor gave me no reason for his decision other than the high degree of emotion of the complainants. And so for 8 months, I did not know who my complainants were, apart from Mr. Cox, who was initially represented by Redwood's lawyers. Neither was I allowed to cite their actual complaints, just given a brief gist of them by the monitoring officer. This was a breach of my human rights against all natural justice. When I was interviewed by Mr. Taylor and Mr. Bainbridge for 2 hours, not knowing who my accusers were and not having seen what the actual complaints about me were. I complained about this to Ms. Cameron when we spoke on the phone. I believe it was August 2020. She said she had recommended to Mr. Taylor that I needed to be given this information and remarked I had been accorded fewer rights and less information about alleged misconduct than if I were a criminal. I told her that I wanted the matter resolved informally, and she said she was of a mind to recommend that to Mr. Taylor. She has not reflected this in her recent statement to the panel. At every stage, I made it clear to the monitoring officer, the independent person, and the external investigator that I wanted this matter informally resolved. In her statement to the panel, Ms. Cameron says that I, quote, I wanted a more formal approach within the informal investigation period. That is not the case. The complete opposite is true. I simply required a note or recording of our meeting. While Ms. Cameron says in her statement of herself, quote, I struggle to remember all the detail, she purports to be able to fully recollect what I wanted. But this is an inaccurate presentation of fact. At every stage, I made clear I wanted an informal resolution to this matter, and I explicitly told her this. In fact, it was always the complainants that would not enter into an informal resolution. This investigation has lasted almost the entire time I have been a councillor, at significant, as yet undisclosed cost to the taxpayer. There have been serious procedural flaws in this process. Mr. Kenyon's conclusions were ultimately based on his preference in interpreting information, not based on clear evidence. Much of what he terms evidence is based on his interviews with the complainants, whose motives he appears not to have probed or considered. I raised this with him on several occasions. I do not find that acceptable, and I don't see why the panel should. He also uses the lens of the newly revised Hazelmere rules as the way to view the determination I took as to whether I should have declared an interest. Rules that were not in place at the time of the vote. This entirely substantiates his view that I should be found in breach of 6(4) and 6(5). This is simply unfair and unreasonable. Finally, this has been a lengthy, expensive investigation in which the monitoring officer has been subjected to extreme pressure by the complainants. A finding that it was all a tornado in an egg cup would be quite embarrassing for the council. Understandably, the panel may feel equal pressure to find for Mr. Kenyon's report, paid for by the council and Waverley taxpayers' funds. However, I ask you to find that the complaint against me is unsubstantiated based on the evidence I have submitted. I also ask you to remember that the previous and well known to be obscure Hazelmere Town Council Code of Conduct is the applicable one here, and the only one against which my complaint of non-declaration of non-pecuniary interest can be assessed. The amended version of the Hazelmere Town Council Code of Conduct has peppered and coloured Mr. Kenyon's report, as many interleaved references to both codes are confusing and cast doubt on his objectivity. Thank you.
Thank you very much. Do you wish to call any witness? A witness, not an advisor.
I'm sorry?
Do you have any witness that you wish to call? That's your advisor. Now I'm asking, do you wish to call any witnesses? It appears not because
No.
it's open. Thank you.
Sorry.
Thank you. That's fine. Okay, the panel now will ask questions or same way as we did Mr. Kenyon. Can I first go and draw your attention to your declaration on page 165 to 169? Because when you were addressing us, you said you felt it was clear in there that you had said you were a member of the Hsra South Residents Association. Can you draw my attention to where it actually says that? Because I just don't see that. It says you've been asked to advise and observe, which is very different to being a member.
I wrote the wording. I have been asked to advise and observe Hsra South Residents Association and represent members, which was at that time over 250 households in Hsra South Ward. I wrote that feeling that it was implicit that I was a member, and simply trying to, in fact, emphasize the fact that I had this association, this representative role, and I genuinely felt that that was clearly implicit in the wording of that statement.
Thank you. Colleagues, any questions? Councillor Reynolds.
Thank you, Councillor Ellis. In your verbal statement you just read out, and we have copies of, you mentioned that, I'll quote, "It should be borne in mind that when I voted, all of the other town councillors who also voted, not a single one declared an interest of any kind." Were any of those councillors also members of Hsra South Residents Association, to your knowledge?
Yes, Councillor Barton.
Okay, thank you. And just a quick second question. In the Code of Conduct, the one which was adopted on May 2019 Hsra Town Council Code of Conduct, under registrations of interest 5.1, it does say, as a member of the council, you must, which is in bold, avoid participating in any decision where you could reasonably be seen as having an interest which compromises your honesty or objectivity. Do you think your membership of the HSRA compromised your objectivity with regard to Red Court?
In respect of the neighbourhood plan and boundary vote, the vote that's under scrutiny, I did not feel that my objectivity was compromised, no, by my membership of Hsra South Residents Association. When the planning committee turned to the issue of Red Court and voted on the planning application, a year later, I declared a non-pecuniary interest.
Councillor Nicholson.
Thank you, Chairman. My question is, after being elected in May 2019 and prior to the meeting in November 2019, the planning meeting, did you publicly campaign against Red Court developments outside the council by, say, writing to the local paper or by any form of social media?
I'm sorry, I didn't quite hear the beginning part of what you said.
Oh, right, yes.
In terms of the time frame, I didn't quite hear you, sorry.
No, I'll say it again. I'll put this down a little bit. That's probably better. Yeah, I was saying, after being elected in May 2019, when you were first elected, and prior to the planning meeting in November 2019, did you publicly campaign against the Red Court development outside the council by, say, writing to the local paper or by any form of social media?
Sorry, you're asking me, did I campaign after the vote that's under scrutiny and the planning meeting, I'm sorry.
No, sorry, I'll go through it again.
Sorry.
It's specific and
Sorry.
No, don't apologise.
Trying to,
it's perfectly reasonable for you to ask if you don't understand the
No,
question.
I
or if
don't, I'm
not putting it
sorry.
forward. Perfectly reasonable. No, after being elected as a councillor in May, you're elected as a councillor, and of course the planning meeting was in the November 2019. What I was going to say, between that time, did you publicly campaign? In other words, through against Red Court, either by writing to the local newspaper or by social media. So in other words, people would know what your clear view was. That's okay.
Sorry. Yes. My answer to your question is that the vote in November wasn't a planning meeting. It was the full council. It was, sorry, the full council neighbourhood plan and boundary meeting. So it wasn't the planning meeting. And I mean, it's quite a long time ago now. I really don't know. I imagine that it would be a matter of public record if I did.
Could I just take you back to the question from Councillor Reynolds, where it said avoid participating, and you said it wasn't the planning meeting, that was the moving of the boundary. I think the boundary, this is only from my mind because I don't know this that well, the boundary had been set by the previous council and then was reviewed by the council elected in 2019. Is that correct?
The boundary that was being discussed was basically the original boundary that had been that had been publicly consulted on when the public were asked as part of the neighbourhood plan research that was done by Hazelmere Vision over a period of 6 years about the green spaces and their attitude to protecting green spaces. So I'm not making myself very clear, sorry. The original boundary was being voted on in that November 2019 vote. And what had happened was that the Waverley Borough Council Planning Department had suggested and submitted a new boundary for the neighbourhood plan. And I hope I'm describing this accurately, but essentially that new boundary would encompass two sites for development, and those sites being Red Court and Longdean. And Longdean is an area of outstanding natural beauty site, and Red Court is a mixture of AONB and AGLV. I hope I've answered that to your satisfaction.
Thank you. I was just interested in that it did move your vote on that occasion. Did that move the boundary to exclude Red Court?
Specifically, the boundary, the vote was about the boundary not being moved. In fact, the boundary staying the same.
To exclude Red Court.
Sorry.
Yes, yeah, okay. I'm just trying to understand how this boundary, you say you had the meeting to discuss where the boundary was going to be. So I'm trying to establish where it was going to be.
Perhaps I can clarify. The boundary was originally along Scotland Lane. At some point, Waverley decided to move it, I think probably unknown locally in Hazelmere, but they moved it to include the Red Court site. When it came back to Hazelmere on the 28th of November, I think it was Hazelmere Vision had put forward that it should be returned to its original line along Scotland Lane. Does that answer your question?
That is now clear, and I understand what the vote was. Yes, thank you. Thank you very much. Any other questions, colleagues? Thank you. In that case, we will move now to the submission of the independent person. Mrs. Cameron.
Hello, I believe you've got a copy of my statement. I don't really have any more to add.
Thank you very much. In that case, I'll ask anybody who has any questions on the independent person statement, colleagues. No? Yes?
Please, I wonder if Miss Cameron could clarify for the panel, please, whether or not she took notes at that telephone interview that she did with Councillor Ellis.
No, I did not.
Then I'd like to please to challenge her words in her statement, if that's acceptable to the chair.
Yes, you can ask questions on it rather than.
Thank you.
And when you're doing it, can you refer to the pages in the report, please?
Now you're asking for something I might not be able to do. Can you turn up Miss Cameron's report for me, please? Sorry, if you could just give us a moment.
If it assists persons in attendance, I think we're looking at page 151 of the bundle, and it's headed, on my version anyway, Annex 5, and then in little print, Annex 5, statement by the independent person, and it amounts to about half a page. I'll help further with pagination if need be.
No, that's very helpful. It's just for the record, I wanted it clear that we were on the right page, but it is page 151. Yes, thank you.
Thank you, Mr. Chairman. It is indeed page 151. I just wanted to clarify when Ms. Cameron says that Councillor Ellis wanted a more formal approach, what she actually means by that, because what Councillor Ellis recalls, and given that it's 2.5 years, so there are no notes of that interview. What Councillor Ellis actually requested was that that interview should be via Zoom, or that there should be a record, some kind of record of it, which, given the circumstances, was quite prudent of her. Can you please tell the panel whether you mean, when you say formal, whether you meant that she wanted a written record of that interview, or whether you recollect that she wanted to come to a formal hearing like this?
No, certainly didn't think it was a formal hearing. It's on. Yeah. A formal hearing. I've done a few of these hearings or these whole processes over the last few years, and I've never been asked by anybody for Zoom meetings and recordings and legal representation. To me, we were in the informal process, so it was an informal telephone conversation, and that was my perspective of it.
Thank you. There are no more questions on this part. In that case, we will move on then to the summing up by the investigating officer.
Okay, thank you, Chair. This hearing is about whether or not Councillor Ellis breached the Hazelmere Town Council Code of Conduct. I want to leave you with some observations about what this hearing, in my opinion, is not about, so that without being at all presumptuous, I can suggest to the panel what might be relevant and what might not. notwithstanding everything that we have heard, this is not, emphatically not, about the process followed before I got involved, or its fairness, or whether there has been what Councillor Ellis calls abuse of process. Most of the allegations about the process that she's raised today were dealt with last year in Mr. Corndall's report, and for the most part were dismissed, and you can find that in the bundle. It is not about how long all of this has taken, how much it's cost the taxpayer, or its effect on any of the participants, and especially Councillor Ellis. I think we can all agree that it's taken longer than any of us might have wished, and that includes me. It is not about the anonymity of complainants, where they live, how much money they've got, what they stand to gain, their motives for raising their complaints, who they are, or what they do for a living. They are just as entitled to raise a standards complaint as anyone else. It is not about whether the complaints were vexatious or malicious, since those are some of the criteria that the monitoring officer and the independent person take into account in deciding whether a complaint is valid and whether it goes forward to me for external investigation. If they considered the complaints vexatious or malicious, they would not have referred them to me for investigation. It is not for me, notwithstanding what Ms. Ellis's legal representative might say, it is not for me to make a judgment on that. It is not about the nastiness and unpleasantness that appears to have surrounded this entire matter, which I naturally deplore and which I would prefer not to be involved in. It is not about freedom of information or subject access requests that are referred to in Councillor Ellis's statement. It is not about conspiracy theories, speculation as to why I might have changed my report, or hints of malfeasance in public office that are made in this report. It is not about any of those things. It is not about alleged breaches of confidentiality. It is not about whether the second draft of my report differed in some ways from the first. The reason for issuing draft reports is precisely to get comments from subject members and complainants before publishing final reports. I'm sure that as a published author, Councillor Ellis understands that. And for the record, I refute completely the spurious suggestion that the report was changed under pressure from the monitoring officer, as Councillor Ellis suggests. That, I'm afraid, is untrue. It is not about the merits of the neighbourhood plan or whether Councillor Ellis was reflecting the views of her constituents on the 28th of November 2019. Nor is it actually, as I've illustrated earlier, about whether she was predetermined or not. And if I might say so, the neighbourhood plan, notwithstanding what Councillor Ellis's legal advisor has said, it is my understanding that the neighbourhood plan was worked on not by Hazelmere Vision, but by the council's working party, of which Councillor Ellis was a member. She worked studiously on, as she has told me, on rewording that plan. And the plan that went forward to the council on the 28th of November was nothing to do with revisions that had been made by Hazelmere Vision in the course of that summer. It was directly as a result of the working party's efforts, and especially as a result of the efforts of Councillor Ellis and I believe at least one of her other fellow councillors, Councillor Weldon, I think. It is not about what other councillors did or did not do in relation to declaring pecuniary or non-pecuniary interests, either on the 28th of November or, for that matter, on any other occasion. What others did is irrelevant, and two wrongs or two or more wrongs don't make a right. It is not about the merits of the case for building houses at Redcourt and the environmental impact or otherwise of that. I imagine we'll all have our own private views on that matter. It's not about whether Councillor Ellis has had her copyright somehow infringed by me, or whether Councillor Ellis was disadvantaged by her own decision not to be accompanied by a lawyer or other person when she and I spoke. Finally, it is not about my suppositions and musings as a former marketing executive, as Councillor Ellis suggests. I can confirm with absolute certainty that I'm not and never have been a marketing executive or anything similar. Notwithstanding what Councillor Ellis said about my report being largely based on interviews, in fact, my report is largely based on hard evidence, and you will see that. Hard evidence from the well, in section 7.3.1, 7.3.2, and 7.9. It is that hard evidence that matters, not what the various interviewees might have said. The driving force behind my report is that hard evidence. So finally, you've heard me talk about the 4 questions that need to be asked, and you've heard my answers. As I say, they're based on hard evidence, not suppositions and musings, not interviews. I don't doubt that you will consider those when you adjourn, since they are the only things that you need to consider. So I will remind you of the 4 questions and the answers. Was Councillor Ellis acting in official capacity when she attended the Hazelmere Town Council meeting on the evening of 28th of November 2019, and at all other relevant times? She certainly was. Was Hazelmere South Residents Association a body, one of whose principal purposes included the influence of public opinion or policy? It is, based on the hard evidence, beyond doubt that it was such a body. It was a body, one of whose principal purposes included the influence of public opinion or policy in respect of Redcourt. And as to that fact, I have no doubt. 3, was Councillor Ellis a member of HSRA, and did she declare that on her declaration of pecuniary and other interest form? She certainly was a member of HSRA, and she did not declare it. 4, should Councillor Ellis have declared an interest in the item that discussed the neighbourhood plan at the Hazelmere Town Council meeting on the 28th of November? If so, did she make such a declaration, and having done so, did she withdraw from the chamber? She should have declared an interest, and she did not, nor did she withdraw from the chamber. The answers to these questions led me to conclude that Councillor Ellis did breach the Hazelmere Town Council Code of Conduct. Thank you for your attention.
Thank you very much. That was very clear. Thank you. And finally, would you like to sum up from your point of view?
Thank you, Mr. Chairman. In his report, Mr. Kenyon has focused some of his thoughts on what the man in the street might think, but unfortunately he didn't ask him. Instead, he substituted his personal views on what which may or may not be accurate, and which may subconsciously have been influenced by his interviews with the complainants and a director of Redwood. And I speak as someone who actually does investigations as part of my business. Mr. Kenyon's other focus has been on the local residents association, which is made up of 350 households. HSRA is a residents association like any other residents association across the borough. Indeed, some councillors on Waverley Borough Council actually represent residents associations. HSRA has been involved in the development of the Heights in Hill Road and also been lobbying Surrey County Council highways because of the dangerous junction with Scotland Lane and the A286. And there was a serious accident again there this week. And HSRA actually hosted the visit by the safety officer from Surrey County Council. HSRA is not just its website, but that was pretty much the only evidence that Mr. Kenyon sought. He didn't interview anyone from HSRA. I suggest that that's a significant hole in the rationale for his conclusions. Councillor Ellis is an honest, conscientious councillor and tried her best to get clarification as to whether or not she should declare a non-pecuniary interest when Hazelmere Town Council debated the draft neighbourhood plan. She was a brand new councillor looking at what Mr. Kenyon himself said was an unclear policy. She talked to people in her community. She consulted with the LGA guidelines, but she never got a clear answer. It was left for her to take a decision based on what Mr. Kenyon recognised was an unclear policy, a policy that actually was unfit for purpose. That policy has now been revised and is significantly clearer, from which we can assume that Hazelmere Town Council accepted that the policy was unclear. Given that to be the case, how can Councillor Ellis be found guilty of failing to understand a foggy policy? If the panel believe her decision or understanding was wrong, that's disappointing, but failing to understand or guess at imprecise rules is not a crime. And over the past 2.5 years, I suggest she has suffered punishment enough. There have been online trolling and breaches of confidentiality. The complainants have stated that Councillor Ellis should be banned, fined a substantial amount of money and consigned to the graveyard of politicians. In a letter to the Hazelmere Herald, Mr. Benson outlined his plan to use the monitoring office as a vehicle to have sanctions applied to Councillor Follows, also on the matter of Red Court. Councillor Ellis declared her interest when the Red Court planning application was debated, but the meeting on the 28th of November was not a planning meeting. It was convened to discuss the draft local plan, a Hazelmere-wide debate with a Hazelmere-wide referendum. I cannot stress enough that that meeting was not a planning application, nor was it a meeting that could actually take decisions. It could only make recommendations to Waverley Borough Council. Never in this long sorry saga has it ever been suggested to Councillor Ellis that an informal resolution was possible. She would have grasped such an opportunity in a heartbeat. It's the complainants that have led us to this hearing, declaring themselves to be implacable in wanting a public hearing. Well, they've got their public hearing, but not the draconian outcome they requested, and by secondary intention, the opportunity for all of this to be in the public domain. In the light of the poorly constituted policy that were Councillor Ellis's only guideline, the vexatious agenda followed by serial complainants, I invite you, the panel, to find the complainant on balance of probability, the complaint on the balance of probability unsubstantiated. Thank you.
Thank you very much. The panel will now adjourn and consider the evidence that we've heard and has been submitted to us. And we will reconvene public when we have come to a conclusion. Thank you. Thank you, everybody, for waiting. We have carefully considered the evidence and the submissions made to us today. We have considered the 4 points made to us by Mr. Kenyon. We find that Councillor Ellis was acting in her capacity as a town councillor on the 28th of November 2019. We find that Hsra South Residents Association was a group who aimed to campaign and influence public opinion and policy. We find that Councillor Ellis was a member of the Hsra South Residents Association, as she gave evidence of today. And we further find that the neighbourhood plan settlement boundary was highly relevant to the Hsra Town Council meeting on the 28th of November 2019. Therefore, having studied the Register of Interest form, we find that Councillor Ellis failed to adequately register her membership of the Hsra South Residents Association and breached paragraph 5 brackets 5 of the Hsra Town Council Code of Conduct that requires registration of non-pecuniary interests. We find that by failing to disclose her membership of the HSRA at the 28th of November 2019 meeting, Councillor Ellis breached the said code. We further find, by failing to declare that interest and failing to exclude herself from consideration of item 109/19, the neighbourhood plan, by withdrawing from the chamber, Councillor Ellis breached paragraphs 5 brackets 1, 6 brackets 4 and 6 brackets 5 of Hsra Town Council Code of Conduct. This is the unanimous decision of the panel. I'd like to thank everybody for attending today, and that brings to an end today's proceedings. Thank you.